All right, another topic. Another topic, and Eddie, I hope you feel that this topic at least has an ethical component to it. It deals with potential perjury.
Potential perjury?
Potential perjury.
Well, I've never seen that in a courtroom.
If it was only potential, it's not an ethical problem.
All right, so what's the lawyer to do when the client is, and again, this is going to be a compound question, the client is contemplating giving what you know to be a perjured version of events, or the client is testifying and the client gives what you know to be false evidence. How do you deal with those situations?
Well, they're two, I think, quite distinct problems.
Right. Well, let's deal with the one where the client is saying, I want to testify, and this is what I'm going to say. You and I know it's false, but that's the story I want to try and sell.
You do that one.
I would say, well, I hate like hell giving you back the retainer that's in my trust account, but here it is. If he insists, I think for your first obligation is to say you must understand that you can't commit perjury. It's a crime. By telling me you're going to commit perjury, never mind it's unethical for me to act for you, I'd be a party to your crime, and I'm not going to do it. If you're intent on committing perjury and you're telling me here now that that's what you're going to do, then I'm gone. I'm gone. Now, it's different than when you're in a trial. It's very different when you're in a trial. But at that point, you do everything you can to get off the record without disclosing to the court that you're acting for somebody that's hell-bent on committing perjury. I don't have a problem with that. I'm not going to stand there knowing in advance that my client's going to commit perjury and him make me or she make me a party to it.
And, you know, we are in complete agreement. And the euphemisms that you then have to use in order to get off the record are sometimes things that can't help but be telegraphed to the judge as to what you're actually talking about. You know, it's usually there's been a breakdown in a sister-client relationship, and the judge is sitting there. Well, what's the breakdown? There can be only a couple of breakdowns. It's either financial or ethical, and usually there's some, you know, at least.
No, there's a third one, and that is that he may want witnesses called that you think are very much against his or her interest to call. I mean, I think there's room for a judge not to know what this is all about.
The second question is equally clear, and interestingly enough, it was, I'm not sure how many of you have ever seen this transcript because it exists, and hopefully the Criminal Lawyers Association has it and can circulate it if necessary, but there was a wonderful ethical panel conducted about 25 years ago where Earl Levy moderated the panel, and the participants were Charles Dubin, G. Arthur Martin, J.J. Robinette, and David Humphrey Sr. And that question was one of the questions put to all of them in terms of what do you do if you're in the midst of the trial, your client's on the stand, and he's now perjuring himself, and it's known to you to be perjured evidence. And unanimously, all of them were of the view that although you could in no way undermine your client at that stage by either stopping the proceeding or making it self-evident to all in the room that the client was committing perjury, you could not pursue the line of questioning. You could just let him complete that answer, and then you could not refer to that evidence in your closing. And that was the ethical responsibility you had when you knew that the person had committed perjury. But there is, I will say to you that very early in my career, and this is sometimes a difficulty, but very early in my career, and this was actually I was acting in St. Catharines on a drug case, and the accused had been a guy who had been, he had been the star of my high school football team where I was the lug on the line, and I was acting for him, and he took the stand, and I had spent ages preparing him and ages involved in the case from the very first moment that he was charged. And he took the stand, and he told a story I had never heard before, from start to finish. It was a new story. and I had no idea why he had told the story. One would have thought that, first of all, it wasn't a very convincing story, and it wasn't as good a story as he had been telling all along. And so I wasn't sure whether he was now perjuring himself or what he was doing. He came off the stand, we had a little chat. I said, "What did you just do?" He said, "I took the Bible in my hand, I swore an oath, I decided I had to tell the truth." And so that was the first time I had ever heard the truth, was when he was on the stand. So that can also happen.
But Arthur Martin actually gave a very nuanced answer to the 25-year-old debate, and it was this. And I had problems with it when I first heard it. And he says, until the client takes the Bible in his or her hand, gets on the stand, and tells the story, you don't know what the truth is. He may have told you a story, he may have changed. I mean, clients change their testimony, change their position based upon either documents or being shown a set of facts that makes their story impossible, so they move it. That's okay. It's the last story that matters when they get on the stand, and if they tell a story on the stand that's different than the one that you're expecting, you don't know whether it's the truth or not.
But that's not the question. The question isn't whether or not they've told a different story. The question was, they're telling a story known to you to be untrue.
No, but
and that's the difference.
Known to you from what they've said, or known to you from what you have seen that independently demonstrates beyond a shadow of a doubt that it's a false story.
The latter.
Well,
you know it's untrue. If you know it's untrue.
But I'm telling you, the way they answer that question is, you know it's untrue because he's been telling you for 3 years the truth that has now changed. And so you know that that's the truth, and he's obviously telling a different story.
I think you can tolerate, as counsel, you can tolerate a change. You can tolerate a nuanced change. You can even tolerate a shifting of how it's worded and perhaps some details. But if the story that's being told is known objectively by other evidence, by the objective truth that you are aware of to be untrue, then you've got a problem in terms of placing reliance upon it in your closing.
Only a problem, but not insurmountable. I had a guy who got on the stand to testify in a trial in front of Judge Locke. He had a great story. Not that great, but it was a good story. And there's an area that I knew the senior Crown attorney would cross-examine him on. I knew it. I just knew it. I knew it. Corruption case from whatever, Woodbridge or that area. And so we had a document in our possession, a genuine document that had been filed with land titles many years ago. It can't be a created document or post-created document. And so I don't ask in this area, knowing that the Crown's going to ask. And my client's going to say, I'm glad you asked me that question. Mr. Greenspan has the document, and I would go up and give him the document. The Crown would say, oh my God, I've been taken down the garden path. The truth would come out and we'd be acquitted. And I bought the champagne already. So the client's asked the question, and he's now supposed to say, I'm glad you asked me that question. Mr. Greenspan's got the document, and he hesitates. He hesitates. I've already pulled out the document, and I'm sitting with it. Okay? And I'm ready. I love this moment. This is a moment that I had planned for, and the client forgot. He forgot. He forgot the truth, and he made up a story. He made up a story that had nothing to do with this document. It was a lie. It's a total lie. And he finishes the lie, and it's now re-examination. What am I supposed to do? Say, you dope? Here's the truth. It would just prove that he's more of a liar than anybody ever expected. And Judge Locke convicted him on the lie. Convicted him on the lie, and the document sat at my table, and I couldn't lead it. But I had to deal with it in my closing submissions to the judge. I couldn't just ignore it, even though I knew he was dead wrong. I had to deal with it, and couldn't.
All right. I don't know whether Paul Cooper or Enzo Rondinelli is going to come forward with questions from the audience, but until that happens, I'll just keep throwing topics out for discussion.
Paul.
Right on cue. What do you have, Paul? Oh, all right. We're going to return to the question of mode of trial. Judge alone or judge and jury? Whose decision is that? Is it the client's or the lawyer's? How much say does the client have in deciding whether it's judge alone or judge and jury?
Go.
I was taught the client has two decisions to make. One, to retain you or not retain you. Two, to plead guilty or not plead guilty. That's their decisions. Other than that, get out of my way.
No, well, actually, there is a third decision. I thought he was going to say the two that I was going to say. The second one is exactly right, plead guilty or not guilty. But it's also the client's ultimate decision if the plea is not guilty, whether the client takes a stand. It is the client's decision ultimately on your advice. Interestingly enough, in that 25-year-old debate with the five great ones, 4 of the 5 said that there were the two, other than the retainer issue, the two decisions that were the client's decision. Mr. Robinette differed from the rest and added form. He was the only one that said the election was the accused election, and therefore the ultimate decision was the accused. The other 4 disagreed with him. And I agree with the other 4.
I'm not going to, if I go to my client and say, I demand that you get on the stand, and he says no, then I'm going to somehow grab him and throw him up there, and make him take the Bible in his hand. I mean, obviously but to me, that's you may yell at each other, and ultimately, if he doesn't want to go, he doesn't want to go. But the basic two are the plea of guilty or not. And then the retainer. You can't make him retain you. But you can teach them to take. You can say to them, "You go in that box. You're going to take a trial that we may well be winning and turning it into a loser." Okay. And I think the persuasiveness of a lawyer in that context of talking to a client essentially takes away from the client the independence to say, "I want to get up there and tell my story."
That was part of your chapter in the book called Playing God.
I didn't mean me.